We have with us Rachael Samberg, who's at the University of California at Berkeley. She's the founder and director of the Office of Scholarly Communication Service at UC Berkeley's library. Rachael's also the director of the Legal Literacies for Text and Data Mining project, including the latest iteration of that, which is a cross-border project. It's an NEH funded project supporting the analysis of legal and ethical issues faced by US digital humanities practitioners, which are one group of researchers that tend to use text and data mining research methodologies that we've been talking a lot about in this course.
So what Eric painted for you is a result reflective of a tremendous breadth of contractual freedom in the United States. In contracts in the US, you can't agree to do something illegal, like we can't agree to murder Eric. And there are certain rights that you can't disclaim if it would violate public policy to do so. But otherwise, what parties make in a contract is pretty fair game to satisfy the breadth of their desires. And what that means as a practical matter is that parties can impose contractual terms that limit or override rights that they otherwise would have had under copyright law. And that's what we saw with the TDM exemption. The exemption that Eric secured for researchers allows the breaking of DRM to conduct text data mining. But we now have a contractual layer that could potentially circumscribe those rights in the agreement that either an individual researcher or an institution signs with the publisher who provides the content. And typically, the kinds of contracts we're talking about here are either database agreements, if it's something that the library at your institution has licensed for researchers, or if you're getting the material online, then it could be website terms of use, which can be enforceable. We typically consider website terms of use to be what are called browse wrap agreements, where you consent to the terms merely by browsing the site. And in some jurisdictions and in some cases, the courts have found those website terms of use to be enforceable. So we have these two prime sources of contracts that can circumscribe the right to research and override rights granted under copyright. The website terms and the databases. And the results of these two different sources of potential override is that publishers and content aggregators have researchers at times over a barrel, and the institutions over a barrel, because there is a tremendous potential for them to maximize profits. Publishers and content aggregators know that researchers want to use this content. And so they take a variety of tacks in kind of regulating access and use of it. For example, imagine that researchers want to do citation mining from aggregations of journal articles. If you want to be able to text mine those materials, and these are materials that are, I should point out, not protected by DRM, under the exemption. You don't need to break any technological measures in order to access this citation information. However, the licensor provides the content to the institution under a contractual term that prohibits text data mining. And they'll potentially say something like, well, if you want the right to do text data mining, to mine these citations, you can give us an extra $250,000. which is not something that most libraries and institutions have. So that is a financial situation that creates a tremendous barrier to research connected to the copyright issue. Because remember, the other thing, what we know about citations is that they're facts. So technically, this information about the existence of a journal article is in the public domain, but now this contractual layer imposes additional limitations on what can be done with that information. The financial barriers also create the possibility of what I call research silos. And that is that an institution might not be able to afford $250,000 to get campus-wide access to the content that researchers want to mine. But the publisher will beneficently offer individual research teams, say for $10,000, a contract that will allow them, for the scope of that one project, to be able to conduct the mining that they want to do. And they offer that to the next research team that comes along. And so you have a series of these silos of research teams that have paid the aggregator or publisher money to be able to conduct research for that one particular project, when still at large, the institution can't ask multiple questions, can't provide access to do the text data mining for the entire campus population, while the publisher continues to derive value from licensing it in these small increments. Remember, I said that there are two avenues typically for researchers to be able to do text data mining. And one is website terms and the other are database licenses. So this is very typical in website terms of use. In this case, the website is saying, actually, you cannot do anything you want to do for your research without asking permission from us. You can't use scraping technology. You can't download content and reproduce the images. If you want to do any of those things, which, as Eric established, we know to be fair use. Now this contractual layer overrides those fair use rights. And, a lot of researchers want to scrape data from social media platforms or from real estate platforms or LinkedIn. In this case, LinkedIn is saying, nope, you can't scrape any of our data. And also, the additional thing that they're adding in here is that you can't bypass any technological protection measures. So even if it were possible under the exemption that Eric secured for everyone, now we see website terms of use that preclude that the circumvention of technological protection. LinkedIn even has an entire site dedicated to how they're policing their prohibitions and in their terms of use. They have a whole explanation for the kinds of profile bots and mechanisms that they use to detect whether or not someone is actually violating any of their terms of use. So it's not just this sort of latent notion in the website agreement that you can't do something, but now they're actually trying to convey to researchers in the penumbra of we're trying to protect data. They're conveying to researchers that they're actually policing the kind of downloading and use that is being made. So what are the possible positives that we could see in an agreement, whether it's a website terms of use, or now we'll kind of switch to the kinds of database agreements at library side. Obviously, we want to advocate for a universe for researchers where fair use is expressly preserved. So what would that mean? It would mean using the website, downloading, creating your corpus, but also being able to conduct text data mining, because we know that to be a fair use as well. merely preserving fair use doesn't necessarily allow you to break DRM to conduct the text data mining, but it would at a minimum preserve the non-DRM protected text data mining research. And you do see some general websites that allow for the preservation of fair use. I should say that if the website terms of use or the database agreement were entirely silent, meaning it didn't say you couldn't download things and do text data mining, but it didn't have this lovely fair use as preserved clause, and instead just had a landscape of silence, well, the default there would be you're allowed to make reliance on fair use as provided by the law. But it is nice to have these affirmative representations that fair use is preserved, whether it's on a website like this one, which is for the Museum of Modern Art, or in the next one, the kind of terms that we negotiate in our database license agreements. And this is model language that we try to include anytime we license content from ProQuest or Wiley or Elsevier or any really large content provider that gives material to campus for them to be able to text data mine. Whether or not we're successful in preserving text data mining, not just fair use, but expressly also text data mining, is really depends on the vendor. We try to reassure them in these clauses that, look, researchers are just doing this. We're only preserving the rights for researchers to do text data mining in the context of nonprofit research. If there were any supposition that a competitive product could result from the kind of research being done, we're not trying to protect that. But even with those reassurances, we can't necessarily guarantee that a vendor or aggregator is going to protect text data mining for us in this way. All of that is well and good. We can largely preserve fair use, and we can often preserve the right to do text data mining as one example of fair use. However, researchers face a very practical barrier when wanting to do that text data mining on ebooks, which is the very right that Eric secured, because the contractual terms for ebooks typically also have a prohibition on circumventing DRM. So now we have 1201 saying you can circumvent DRM for ebooks, and now we have, in this case, Amazon Kindle saying, no, you can't circumvent DRM to do this. It's not possible for researchers or even libraries to easily negotiate with Amazon to be able to get a waiver of these kinds of anti-DRM circumvention provisions. And that's not to fault Amazon necessarily. I mean, Amazon may not even be the rights holder for the books. They may just be the distributor. Amazon would need to ask the publisher for permission to waive the anti-DRM circumvention provision in some cases. So as a practical matter, it's not easy to navigate these barriers, especially for ebooks where there is almost certainly going to be this contractual layer prohibiting the circumvention of DRM, regardless of what 1201 says. So just to recap the landscape for what you see with contractual override, or what researchers see for contractual override. If the contract is entirely silent on fair use and TDM, then the default rules apply. Fair use is okay, TDM is okay, and breaking DRM to do the TDM is okay because Eric got you that right. Second, if you have a contract that says that fair use is expressly preserved, but is silent on text data mining, then fair use is okay and text data mining is okay because we know text data mining to be a fair use. And breaking DRM is okay to do the TDM because of Eric's exemption. If you have a contract that says fair use is expressly preserved, but text data mining is prohibited, then that's exactly the case because of contractual override. Fair use is okay, but no text data mining. And same thing with fair use being expressly preserved and text data mining being permitted, but breaking the DRM to do the text data mining being prohibited, then yes, you can make fair uses, and yes, you can do text data mining, but no, you can't break DRM to do the text data mining. So where does that leave researchers? The impact of all of these contractual terms is that researchers need to do a risk assessment when they conduct TDM, and also if they want to break digital rights management to conduct TDM. And I want to just flag here that a lot of researchers are unfortunately misinformed at the moment and think they don't need to do that risk assessment in light of some recent cases. So a recent Ninth Circuit ruling, HiQ Labs versus LinkedIn, combined with a US Supreme Court decision from 2021 in Van Buren versus the United States, involving unauthorized access under the Computer Fraud and Abuse Act, which is a criminal statute, suggests that courts don't view the scraping of public information as a violation of the Computer Fraud and Abuse Act. But these cases have been widely misinterpreted by the public through no fault of their own, but really due to kind of lax reporting by journalists, as somehow standing for the proposition that it's okay to scrape anything you find online. No, the cases said that scraping a website that is properly accessible to you, whether it's because it's public or because you have licensed access to it, in violation of the otherwise terms of use, is, if it's not an unlawful access, it's merely not a violation of the criminal statute. It doesn't mean that what you're doing isn't a violation of a contract. It is still potentially a breach of contract. So that's why researchers need to pay attention to the underlying license agreements and website terms of use. And they have a risk management question to face. What the risk management question centers around are, what are the implications of merely violating a contract? What is the likelihood of meaningful consequences for researchers if they or their institution violates the database agreement? What is the likelihood of a lawsuit being filed either against the researchers or the institution? And will that lawsuit contain seeking damages beyond just nominal damages for merely violating the agreement? Or, well, what are the actual damages that a publisher or vendor has suffered if you have violated these terms? And unfortunately, the answer to these questions really varies. I would say that a takeaway is maybe that a risk calculus would enable that a researcher using a public website not to fear significant enough repercussions in violating the terms, but the same is not necessarily true for a researcher using content licensed through a database. The ramifications of violating a database agreement are likely to be more significant. The most immediate result of a researcher violating a database agreement is that access to that resource is shut down for the entire campus and potentially not restored. And there are now also subsequent retraction fears for the papers that researchers publish using the information that they've gotten from content that they shouldn't have or that they violated. Beyond that, it really depends on what the terms of the institutional license agreement are and what the scope of damages are in what the institution has signed. But the financial implications of breach can be significant, and it needs to be part of what a researcher considers. All of this obviously has an impact on the global right to research. In our first project or institute that Sean mentioned at the beginning, building legal literacies for text data mining, we trained researchers, specifically digital humanities researchers, on all of these kinds of legal literacies that they need when doing text data mining. But that's a set of 32 researchers. That's not, teaching all scholars around throughout the country or even around the globe what their rights are and how contracts can override their right to research. We are now in sort of phase 2 of this work looking at cross-border problems with these contractual override issues and all of the other rights literacies for researchers. So while contractual override may be a problem for US researchers, researchers in the UK don't necessarily face the ability of an agreement to prohibit text data mining that would otherwise have been allowed. And so if researchers are collaborating cross-border, whose law applies? If they're working with data licensed by researchers in another country, do that country's laws mean that it's okay? And whose database laws apply there? So this is really kind of the next phase of examining how these contractual barriers impact the global right to research. You know, we don't have answers to that now, but Dave Hansen has some ideas for how we're going to start addressing the issues that I've raised.